Well, good morning, everybody. Anybody got a contractual issue they want to cover before I start into what I've got? No? Okay. So we're dealing with an insurance thing right now. We represented a buyer, and the transaction went through. We represented actually both buyer and seller, two different agents representing a buyer and seller, but we were dual agents, but with two different agents. The buyer bought the house and then got it insured. It's up in Lake County, got it insured with Farmers Insurance. And then Farmers sent out an inspector, insurance inspector, and they noted electrical panel that they don't approve of it anymore. It wasn't the old zinc on one, which, you know, gets highlighted in many contractor reports, home inspections. They always highlight the zinc on ones, and that becomes an issue about replacing them. But this was a different panel, and you know, no one, our agents weren't aware that it was not approved by certain insurance companies. And it's not necessarily all insurance companies, but it's on Farmers' bad list. So they told the buyer, this is after close of escrow, probably a month after, that, oh, because you have that panel, your premium is going to go up $2,000 a year or $1,200 a year or something like that. And that didn't make the buyer very happy. So they said, well, what if I change out the panel? And they said, fine. If you change out the panel to an approved panel, then your insurance would stay the same. So that's what he decided to do. And then he started looking into things, and he said that the seller had had a fire in the house, which we weren't aware of. And that it was caused by that faulty panel. And when she, the fire was in the kitchen, and she rebuilt the kitchen and put a sub panel in to take surge off of that main panel that was faulty. Now, that's all kind of him making up that story, because we don't know if that's exactly what happened. We haven't been able to talk to the seller yet. But it brought up for me, you know, we used to get clue reports, CLUE, for those of you who've never heard of them. And they were insurance companies have to put into this database any claims against the house by address. And so it comes out in the form of what was called a clue report. And so I asked, you know, I haven't seen any lately, and we used to be required in our transactions. And I asked Bill Jansen, our risk management attorney, are these things still around? He says, yes, they're still around. But when they changed the access rules so that only the property owner can order a clue report. So CAR dropped them out of the RPA, where they used to show up as a recommended thing that a buyer get, because the buyer can't get one, only the seller can get one. They're available. I mean, you could order a clue report on your home. You just kind of go through your insurance agent and get a clue report. So the bottom line is we're still figuring out this insurance thing, whether we had any knowledge of this or just something that happened after close of escrow, and then the buyer is responsible for it. And you know, that's just the buyer's bad luck, in the sense that the insurance company is making them change that. But looking into insurance is very important. And let's go to the RPA and first. And in paragraph 8A2, okay, here RPA. Paragraph 8 is contingencies and removal of contingencies. And under A2, which is actually A is loans, but under A2, 8A2, it says buyers advised to investigate the insurability of the property as early as possible, as this may be a requirement for lending. Buyer's ability to obtain insurance for the property, including fire insurance, is part of the buyer's investigation of property contingency. Failure of the buyer to obtain insurance may justify cancellation based on the investigation contingency, but not the loan contingency. So they're advised there to get, investigate insurance. Now, this buyer did, and he got insurance, so that wasn't the issue here. But then in the statewide buyers advisory, which is part of all of our contracts, all of our files, statewide buyer and seller advisory. And this is this beautiful 14-page, 67-paragraph form. Page 6 paragraph 8 deals with insurance. Since the buyer and seller advises, buyer may have difficulty obtaining insurance regarding the property if there has been a prior insurance claim affecting the property or made by buyer but unrelated to the property. So even the buyer, if the buyer is making claims and has a history of making claims, they may have a difficult time getting insurance. The seller is required by CAR form RPA to disclose known insurance claims made during the past 5 years in the SPQ or the ESD. Sellers may not be aware of claims prior to ownership. If buyer wants additional information, brokers recommend that during buyer's inspection period, buyer conduct his or her own investigation for past claims. Buyer may need to obtain seller consent in order to have access to certain investigation reports, which is they're referring to the clue report there. And then if it's a condominium or so, you should check out the condominium's insurance, because we had a sale recently where the homeowners association had let the insurance for the entire complex lapse. And we couldn't get insurance on a home in the complex until the homeowners association reinstated their insurance. So insurance is a big deal. And let's just take a quick look at the SPQ. Seller property questionnaire. And down here under question 6H, the seller is asked, are there insurance claims affecting the property within the past 5 years? Yes, no. And if they answer yes, then they're supposed to explain. Okay. So insurance is covered in all those places, and it's very important. In this case, the buyer now thinking that we as agents knew about this fire and never disclosed it. And the fire was never reported to like the fire department, but there was an insurance claim made. So he found through his insurance agent was able to pull a clue report that did show this fire in 2018, that there was an insurance claim from this fire in 2018. Now, so the seller still, we haven't talked to the seller. The seller checked no on the SPQ. So that leaves us to say, well, what happened there? Seller, why didn't you check yes and provide the information? The buyer's thinking that it was all, this fire was tied to this faulty electrical box. We don't know if that's true or not. It could have been a grease fire in the kitchen or something else. And something else in the remodeling of the kitchen triggered a new sub panel or something. We don't know the details until we talk to the seller. But insurance, complicated and important. So make sure you discuss it with your buyers and sellers in your process. Yeah, Patty.
Just, I don't know if you brought this up recently, but a lot of insurance companies are not renewing in high fire danger areas. I don't know if you've talked about that.
Yeah.
And
so
the people are paying large amounts for insurance now.
Right. And there's talk that the state may step back in and offer some insurance as they did after the fires.
I get it, but it's only fire.
Right.
There's a whatever. My neighbor he's paying $5,000 a year for his insurance now on his home.
Yeah.
They canceled nationwide is getting pretty much canceling everybody in the high fire danger area, or not canceling, but not renewing. They didn't do that to me, but they did it to my neighbor, and they did it to my house in Carmel, which is interesting, which is not that high of fire danger theoretically.
Right.
Yeah.
Okay. Well, yeah, another important reason for the buyer to check out insurance, because it could be a financial burden much higher than they expect during their contingency. And it's important to maintain that contingency, even if you, let's say your buyer wants to waive inspection contingencies. Well, make sure they don't waive insurance contingencies because, PJ says you could get insurance through the FAIR plan, which is the state plan. And I think it's just a cost issue, PJ.
The FAIR plan, I believe the FAIR plan is only fire.
Yeah.
So it's not liability either. So.
Yeah, well, you could maybe get supplemental policies.
Right. That's why he had to pay. He had to do two insurances and cost total
exactly.
$5,000. Yeah.
Right. Okay. Yeah. So she said you can get an endorsement for theft and vandalism. Thank you. Insurance, be sure to check it out on both ends as a listing agent and as a selling agent. Make sure your seller knows they have to disclose any prior claims that they're aware of that within 5 years. We had an issue come up about we have a property that's largely agricultural and but does have a small residence on it. So the question is, if a contract is written up on the RPA, is there a contract, an attachment, an addendum we attach regarding the agricultural nature of the property? So let's look at that. Back here. So we're looking at agricultural addendum. So this is for improved properties, for use with improved properties, not for use with vacant land purchase agreement. There is a vacant land purchase or vacant land advisory, or what do you call it, disclosure and advisory, that gets used with the vacant land purchase agreement. So you would use the vacant land advisory or disclosure with vacant land, but with improved properties with that agricultural component, you use this one. And it has lots of information about seller documentation and additional disclosures. There's 14 items there. that the seller needs to be aware of in terms of their disclosures, rental and service agreements. Say you have a vineyard that's subject to a lease, that obviously has to be disclosed and given to the buyer. And other things about the agricultural nature, hemp and the cannabis cultivation. This particular property is in an area where and in fact, I think I'm told it's approved for marijuana cultivation. So this form covers all of that stuff. And so use it when you're dealing with ag property with an improvement on it, with a home on it. Okay. Any questions on that? Okay. We're also attaching the the county disclosures and disclaimers also deal with ag. So we're also covering it in those documents. So question came up this week on the COP. And that's not your breathing disease, which is COPD, I think. But the COP is contingency for sale of buyer's property. And for the last dozen years, we've rarely seen offers coming in from buyers where they have to sell their property, because it's been such a strong seller's market that buyers, been advising buyers, you better get your property in contract first or sell it first before you try to go buy a property, because you're going to be in competition. And if you submit a COP, contingency for sale of your property, everybody's going to laugh at you and you won't get accepted. Well, the market's changed, as we know, and I think we'll start seeing more of these. We just received one this week, and the agent hadn't seen one since 2011, I think he said. So yeah, this is a somewhat complicated form because there's a lot of check boxes here. Is the buyer, and the one we got, the property was not, they will be entering into a contract for sale. So they hadn't even listed the property yet. And so, oh, that's a contract. Somewhere it said the property wasn't even listed. Oh, here it is. Listing in MLS time. Buyer has signed a listing agreement, or shall within 3 days after acceptance sign a listing agreement. So they hadn't even signed a listing agreement yet in this case we got. And so one of our feedbacks to the agent representing the buyer was, well, what are you going to list it for? And show us a copy of your proposed listing agreement. We want to see what it says, so we can, our seller can evaluate whether it's a saleable property or not. So this form, you should go over it carefully. If you get one, if you receive one on one of your listings, you're going to have to go over it carefully with your seller. And this paragraph 7 is kind of the most complicated one. It says backup offers a seller right to require buyers to remove contingencies or cancel. So 7A says the seller has the right to continue the marketing the property and accept backup offers. And it says 7B, a removal of buyer's contingency, unless paragraph 7.6C3 is selected, which is down here further. Seller accepts a written backup offer and provides the buyer a copy of that offer. Then the seller shall have the right to give the buyer notice to remove their contingency on the sale of their home, remove the loan contingency, if any, and provide verification of sufficient funds to close escrow without the sale of buyer's property. So that's a written request, they can do that. And if buyer fails to complete these actions within 2 days is the default, after delivery of such a notice, seller may then immediately cancel the agreement in writing. Okay, so you go on to paragraph C, 7C, time to give notice to remove contingencies. Seller shall have the right to invoke the notice of provisions in 7B, that's the notice, C1, immediately upon immediate right to notify buyer. That's anytime after acceptance. So you go into escrow, you have a 17-day contingency period, but in the 5th day, the seller gets a backup offer they want to take instead. They give immediate notice to that buyer and usually bump out the first buyer because they can't perform. And then there's 6C2, delayed right to notify buyer no earlier than 17 days after acceptance. So now you're going to give this first buyer their 17 days to try to sell their house. But if it gets to the 18th day and they haven't sold their house, then you can give them the notice and bump them out. Now, in this case, this was filled in at 30 days, and the original up here asked for 30 days contingent up here, that the sale was, they had 30 days to get a contract on their house. So that's something that our agent was concerned about. And I said, hey, that's for you to go over with the seller and see if the seller's happy with it or counter it. And then there's C3, which is no right to notify buyer until this term has expired up here, 30 days. So the form is, like I say, complicated. Here's that part where the seller can use this form to give the buyer notice to remove the contingencies and so forth. And we may see more of these because in a more normalized market, we often see people who want to buy up, they've got equity now in their home, but they want a bigger home, but they have to sell their, their original home first, and we see these COPs come into effect. So look over those forms carefully if you're dealing with that. Any questions on that? Everybody's gone blank on the screen. I'm the only one here. Let's see. Next thing we've had come up this week is contract cancellation. So we had a buyer and they got into contract on a mobile home and they removed the contingencies. Everything was going fine. At the beginning, the buyer had told the agent that the money was in the trust, so it was written up in the name of the trust, using the proper place in the RPA. And but it turned out that the buyer had been ill, and during his illness, the brother had appealed to the court for conservatorship, and the trust was now being held in a conservatorship by the state as required by the court, and the brother was administrating. And the brother didn't think the client should be buying property at this point. So the client had recovered from his illness, but hadn't taken the steps to get the trust back in his control. And the trust had plenty of money, like 5 times as much money as needed to buy the property, but he didn't have access to it. So he's got to go back to the court system. Well, this kind of got discovered late in the game after all the contingencies were removed, and it seems it's going to take several months to complete that. They'd already extended the escrow one time. The buyer said, oh, let's just cancel. I don't want to hold this seller up while I'm trying to get this released. When I get the money released, we'll go buy another one. Okay, that's fine. But were they subject to loss of their, their liquidated damages deposit, which in total, because it was a mobile home, relatively inexpensive, I think it was $100,000 or something. The deposit up was $3,000. So the space rent on the place was like $700 a month. Our buyer says, well, $3,000, I don't want to lose all that money. I'll offer him $2,000 because that pays for a few months of space rent while they get the house resold and closed. So they filled out this form, the cancellation of contract, and properly, and they said partial release, where it here under C3, a partial release of $2,000. And sign that and send it over to the seller. Well, the seller wants the full $3,000. So we don't know how it's going to be resolved because this is still in play. Obviously, you don't want to go to court over, this kind of funds, and so far, we feel it's mostly the seller's agent who's pushing back on this rather than the seller necessarily, because there were valid reasons for this cancellation, and the $2,000 seemed like a reasonable offer. But it brings to mind what I said last week, that it's not our house, it's not our money, it's not our decision. Okay, it's not our house, it's not our money, it's not our decision. So that we, represent our client to the best of our knowledge and skill, it's really still the client's decision whether they want to, what they want to do here. So if the seller pushes back and rejects this form, we're waiting for them to do so in writing, because we already submitted something in writing to them. So like a counteroffer, it's in their ballpark to submit something back to us. So we're just kind of being patient at this point. But if our client ultimately decides that they want to just let them have the $3,000, and that's their choice, not our decision. It's not our money, it's not our decision. Okay. Any questions on that?
I have a question.
Yes.
So since it's by no choice of yours being the agent, I mean, if it did happen to end up going to court, is that something that we would have to go to court with them for, or, our legal team or whatever, or is that just between the two of them?
Well, in this case, the amount is such that they'd probably go to small claims court. Let me be clear about our attorneys, our broker risk management team. They're there for us as broker and agents. They will counsel us on issues that involve us as brokers and agents. They don't provide counsel for our clients.
Makes sense.
Yeah. Now there is a group, our group up in Humboldt County have been using a group where the seller or the buyer can buy for a fee legal coverage. And in those cases, that group will represent a buyer or a seller if they bought that coverage.
Okay, thank
but
you.
For the rest of us, our legal counsel just represents us. So you got to be sure that we can't provide legal counsel to our clients. That being said, we do usually hold their hands through this process. I mean, if that's what you want to say, we give them support. If there's a mediation where one party, let's say the buyer has called our client seller into a mediation, We aren't part of the mediation, but we'll often attend the mediation just to give our clients support and to tell our side of the story as we understand it, even though we aren't part of that mediation. And we might attend, I've attended small claims court with a client, just to give them the support there. And the judge asked me several questions, about the transaction, and, we were just helpful, but we weren't part of the transaction.
Okay, thank you.
Okay. Let's see what else we got. I got another form here. I'm going to try to find. Hold on just a second. Close this out. This, okay. So this came up just yesterday. Okay, I'll share it here. All right. So this is a counteroffer. Our agent represented the buyer, made an offer on the property. Seller made a counteroffer. And you can see here under other terms of the counteroffer, C, it says the seller will credit the buyer 3% for closing costs, or maximum allowed per lender. I don't know what that means necessarily, but and then number 2, buyer investigations and reports are for informational use only. No additional credits will be given for any repairs. Property is sold as is. So our agent asked, well, what does that mean? That would the buyer still have a right to cancel if they found something in the investigation reports that they didn't like? Or is this paragraph or this language C2 here say that they couldn't cancel? And of course, it doesn't say they couldn't cancel. They still have the right to do their investigations and get reports. And if they find something they don't like, they could cancel. But beyond that, the contract allows them to make requests for repairs. And even though the seller is saying here that they aren't going to give any additional credits or for repairs or anything else, and it's purchased as is, well, the contract says it's being purchased as is. So they aren't saying anything new here. And if something's found along the way, before the buyer just cancels, they could actually make a great request for repairs, even though this paragraph is there. So if you're writing this language, it doesn't do you a whole lot of good. I guess that's what I'm getting at, because it has no weight. It doesn't change the initial RPA, which says the buyer can do these reports and they have the right to ask for repairs. It's kind of bluster with no impact. So that I wouldn't encourage you to write that kind of paragraph. I guess is what I'm saying. Now, your seller might want to say, oh, I'm selling the property as is. And you just point out to them the RPA, that paragraph that says the property is being sold as is. I mean, it's right there. So, but the buyer does have a right to make a request for repairs, and the seller isn't obligated to accept that. Yes, Steve, you have a question?
Well, on that first paragraph that you had, where seller to credit buyer 3%.
Yeah.
One thing I write in my contracts is the words up to 3%. Yeah. And the reason being is that sometimes the buyer can't take the entire 3%. And then all of a sudden now they want this and they want that, and it leads to issues. Yeah,
that needs to be explained to the buyer and discussed before the buyer agrees to take a credit or asks for a credit. You need to discuss that with your lender. Your lender is your partner in these transactions when you're representing a buyer. And you need to be in close touch with them and say, okay, we're going to ask for credit for closing costs. How much can it would be allowed? So I like the language up to, but you need to explain that to the buyer, why you're saying up to. Thanks for that. And let's see, got one more thing here. I've said a few times in recent emails, and hopefully you've seen it, that we're going to cover the FH or FDASH or the FHDS or whatever it is, the fire hazard disclosure next week, FHDS, in detail with Bill Jansen. He's going to take about a half hour and go over the form in detail again. And partly of what he's going to go over is this defensible space decision tree and how this thing works and how we walk through it. Now, one of the good things about the CEAR training that is available and that I've sent you the link to is that they spend about half the time showing us how they can you can use the ZIP community to send your client these forms. And it allows them to fill them out online, like the TDS or the SPQ. And then you can review them before having them signed. And they point out in that that training, and I'll send it out as a link again when I send out this recording. So keep an eye on it if you haven't taken that training. It's a 1 hour training, but it's worth looking at because you'll really understand the form a lot better and how to use it, and how to use zip forms to get it to your client. But if you have multiple sellers, when you're setting up your file in zip forms, make sure that seller number one is the one that's going to answer those questions, because the seller number one will be the only one in the forms, zip forms community that will be allowed to answer those questions. Now you can send it after it's all filled out and ready to go. You can send it to all the sellers for signature, which is the proper thing to do. But only one of them is going to fill it out, and you need to make sure you have the one who is going to fill it out as seller number one in your setup. So that's all covered in that training. Have any of you gone through that training on CAR? Raise a hand, say yes. Okay, well, if you're dealing with sellers, you're going to deal with this form, and it's worth knowing in good details. So just set aside an hour and do the training on CAR and tune in next Friday at the same time, same station. And Bill Jansen will be doing his training on that. Okay. So that's all I had for today, and Heather's off at some training of some sort. I'm not exactly sure what. So any other questions before we tune out? Parmita, you raised your hand. Go ahead.
Sorry, I missed where you said we could find that training link. Was it?
I'm going to send it. I'm going to send it again when I send out the recording this afternoon.
Oh, perfect. Thank you.
It'll be attached again, but it was in a prior email I sent earlier this week also. I think on Monday or Tuesday about the training that was coming up today. I talked about the training a week from today and also included that link.
Okay, I'll take a look. Thanks.
Okay. Patty?
Yeah, I just went to it today, started listening to it, and you send a link, it goes to the live, and you just scroll down and find the one that's on that particular subject.
Right. Yeah, you hit the link and it'll bring up several webinars, and you have to go down one or two or three to find the one about the FHDS. So, yeah.
You actually have to log in, otherwise it won't let you in. So.
Yeah. Obviously, you have to log in the CAR. So, yep. Thanks, Patty. Okay. Any other questions? All right. Go list a house. Go sell a house. Have a great week.
Thank you.
Bye, everybody.